Raymond Kwong. So DRC was formerly known as Protection and Advocacy. We're a nonprofit organization. We provide legal services for people with disability. We are a nonprofit. We provide services on special education, public benefits, regional center services, housing, employment, and many others. We have offices in Sacramento, Los Angeles, Bay Area, and San Diego. Our smaller offices are in Fresno, Ontario, and Modesto. If you have any legal questions today and would prefer to speak to somebody privately, we will leave our intake line on the chat. Feel free to reach out to us through that way as well. Thank you, everyone. And I'll now turn it over to Raymond Kwong.
Good afternoon, everyone. Thanks for having us again. As Lonnie stated, we have two presenters today. First, we have Daniel Hernandez, who is a legal clinic attorney with the Advocacy and Community Engagement, or ACE group at Disability Rights California. He was born in Santa Ana, California, to Mexican immigrant parents. He began practicing law in 2021, and he has experience in immigration, housing, and some public benefit matters. And another presenter, Nadia Jeiroudi, is a legal fellow with the Legal Clinics Project, with the Advocacy and Community Engagement Group here at Disability Rights California. So without further ado, I will give the floor to them and they can begin.
Thank you so much, Raymond. I'm so sorry, everyone. My camera just went purple and now it's not working. So I'm going to be presenting without my camera. If it ends up working, you'll be able to see me, but we're going to just try and go with the flow on this one. So today we are presenting on California Children's Services, which is a California program. So let's get started. So we just want to provide a disclaimer that this presentation is meant for education only. It does not constitute any legal advice or counsel, as your situation or matter may be unique and personal to your own circumstance. And also we try our best to update the information as consistently and accurately as possible. But as we all know, law and policies always change and often very quickly. So it is possible that something written in this PowerPoint today might be out of date. So we just wanted to point that out. All right, so we are going to give a quick overview about what we will be discussing today. We are first going to give just a quick 101 on what the California Children's Service Program is, followed by what is the Whole Child Model Program, which is kind of part of CCS, eligibility requirements, services, how to apply, and the appeals process. All right, so what is CCS? CCS is a program that provides diagnostic and treatment services, medical case management, and physical and occupational therapy services to children under the age of 21 with CCS eligible medical conditions. So CCS authorizes medical services, rehabilitation, and equipment that are medically necessary for the CCS eligible condition only. Examples of CCS eligible conditions include, but are not limited to, and we will provide a link and more information on the types of conditions that are included, but they include things such as chronic medical conditions, such as cystic fibrosis, hemophilia, cerebral palsy, heart disease, cancer, traumatic injuries, and infectious diseases. And it also provides medical therapy services that are delivered at public schools. So the CCS program is administered as a partnership between county health departments and the California Department of Healthcare Services, known as DHCS. Currently, there are approximately 70% of CCS eligible children that are also Medi-Cal eligible. And I believe it's around 77%. So under that program, the Medi-Cal reimburses their care. The cost of care for the other 30% of children is split equally between CCS only and CCS healthy families. The cost of care for CCS only is funded equally between the state and counties. And the cost of care for CCS healthy families is funded 65% through federal law, 17.5% through state, and 17.5% through county funds. So as you'll see, CCS is really between the state and the counties, and there's a lot of county involvement with the California program. Next slide, please. So within CCS, as previously just discussed, county division is really important. So there are dependent counties and independent CCS counties. And what do those terms mean? So in counties with populations greater than 200,000, those are considered to be independent counties. And in these counties, county staff perform all case management activities for eligible children residing within their county. So this includes determining all phases of program eligibility, evaluating needs for specific services, determining the appropriate providers, and authorizing for medically necessary care. So that's independent counties, more than 200,000. When there are counties that are less than 200,000, those are called dependent counties. And for counties with population under 200,000, the Children's Medical Services CMS branch provides medical case management and eligibility and benefits determination through its regional offices located in Sacramento and LA. So dependent counties interact directly with families and make decisions on financial and residential eligibility. Some dependent counties have opted to participate in the Case Management Improvement Project, which is also known as CMIP, to partner with regional offices in determining medical eligibility and service authorization. So regional offices also provide consultation, technical assistance, and oversight to independent counties. And so these regional offices oversee those independent counties and providers within their regions. All right, next slide. Okay, great, thank you. So within CCS, you will often hear these two terms, carved in and carved out. And it can be a little confusing, and we will discuss an example on this slide. So if services are carved in, what that means is that payment for those services is the responsibility of the Medi-Cal managed care plans. And Medi-Cal managed care plans, MCPs, are responsible for authorizing and coordinating CCS and Medi-Cal services. And so those plans have CCS carved in. The MCP will be responsible for that payment and for coordinating and authorizing those services. When a CCS service is carved out, that means CCS is responsible for authorizing CCS services, and they are paid by fee-for-service Medi-Cal. So the CCS provider bills the state who pays for the services. Generally, Medi-Cal managed care plans, MCPs, are responsible for providing prevention, primary care, and other medically necessary services that are not related to CCS eligible medical conditions. So reimbursement for medically necessary services to treat a child's CCS eligible medical condition are considered to be carved out of most MCPs, which means the MCPs are not the ones responsible or participating to provide those services for the child's CCS eligible medical condition. So when we think of carved out, CCS is the one responsible for authorizing those services, and it's paid for by fee-for-service Medi-Cal. When it's carved in, the Medi-Cal managed care plan is the one responsible. So on that link there, you will see it's a chart from San Mateo County. It's from 2015. It might be outdated, but it's a pretty helpful visual to see the breakdown of CCS carve out and CCS carve in services. So that chart there will show services such as financial risk, provider payments, service authorizations, care coordination, and appeals. So for example, for a CCS condition, let's say cerebral palsy, a CCS carve out, which as we mentioned would mean that CCS is responsible, would be that the state and county would pay for all CCS services when it comes to financial risk. If it is a CCS carve in, the state would factor CCS services into the health plan's overall member rate, because as we discussed, it is the Medi-Cal managed care plan that is responsible. So it's a little confusing, but that chart, that visual will really help, and we'll also be taking questions after a few slides on this if anyone would like any clarifications. Next slide, please. All right, so we just spoke about what is CCS. That was a pretty brief overview. We are next going to talk about the Whole Child Model Program. All right, so prior to the implementation of the Whole Child Model Program, CCS services were carved out. They were separated from most Medi-Cal managed care plans. But CCS became a Medi-Cal managed care plan benefit in select California counties starting in July 2018. And the goal there was to improve healthcare coordination for the whole child rather than handle CCS conditions separately. So this approach became known as the Whole Child Model. So Senate Bill 586 authorizes the Department of Healthcare Services to establish the Whole Child Model Program in designated county organized health system or regional health authority counties to incorporate CCS program covered services for Medi-Cal eligible CCS children and youth into a Medi-Cal managed care plan contract. So this was supposed to be developed no sooner than July 2018, and the counties listed there with the 5 health plans have developed them. And the results are to be improved care coordination for primary, specialty, and behavioral healthcare services for both CCS and non-CCS conditions. And the Medi-Cal managed healthcare plan here is responsible for authorizing those CCS services, processing claims, payments, and quality oversight. So there are 21 counties that participate in this, and it's under 5 health plans. So you'll see here the 5 health plans are CenCal Health in San Luis Obispo and Santa Barbara counties, Central California Alliance for Health in Merced, Monterey, and Santa Cruz counties, Health Plan of San Mateo in San Mateo County, Cal Optima in Orange County, and then the Partnership Health Plan of California, which is in the remaining counties. And so the CCS Whole Child Model Program can help pay for services and treatments if they are medically necessary. So examples are pretty vast. It can be doctor visits, hospital stays, in-home nursing services, supplies, lab tests, medical equipment like wheelchairs, medicine, therapy, surgeries, mental health services. It's quite vast. And we provided 2 publications there. One is the DHCS document on the Whole Child Model. And then there is also a Disability Rights California publication on the Whole Child Model Program. Great. So next we are going to talk about eligibility. And so CCS makes all CCS eligibility determinations, even if your child participates in the Whole Child Model Program. And to get CCS services, your child must meet a few requirements. So a child may qualify if they meet the age. They have to be under 21 years old. Certain income requirements, medical requirements, which basically means they have to have a health condition covered by CCS, and residency tests. So we're going to go over each of them. First, the age, your child has to be under 21. And if we'll go into the next slide, we will talk about income. Great. So unlike Medi-Cal, CCS only looks at income. So what you earn from working, for example, not resources. And so your child will meet the CCS income test if your family's adjusted gross income is $40,000 or less per year in the most recent year. However, if your adjusted gross income is more than $40,000 per year, your child may still be eligible if the estimated cost of your child's care, which is basically out-of-pocket expenses, for 1 year will be more than 20% of your family's adjusted gross income. So for example, let's say your family's adjusted gross income for the most recent year was $60,000. So that would be more than $40,000. And you might think, you might not be eligible. However, the cost of your child's care for 1 year is $15,000. That is 25% of your family's income. So the fact that the adjusted gross income for your family is more than $40,000 would not prevent your child from being eligible because their cost of care is more than 20% of that adjusted gross income. You may also not have to, your income may also not matter if your child was adopted and had a CCS eligible condition at the time of adoption. When that happens, the adopted parent's income will not matter. It is also important to note that family income includes only income from the child and the natural or adoptive parents. So CCS is not allowed to count other family income, such as child support for a brother or sister, income from a stepfather or who has not adopted the child, or from any other adult in the household. And there are also other exceptions where family income will not be taken account. If there is a need for an evaluation to find out if there is a health problem covered by CCS, family income will not be accounted for. And if the child is a Medi-Cal recipient receiving full benefits, CCS will not look at family income for eligibility. Next slide. So if your family exceeds the income limit and your child is not enrolled in Medi-Cal, your child may still be eligible for occupational and physical therapy services provided free of charge through CCS's medical therapy program. So what the medical therapy program is if your child is in school and needs medical services, as we mentioned, physical or occupational therapy, in order to do better in school, CCS will waive the financial eligibility standards no matter what your family income is and without a share of cost or enrollment fee. The caveat here is that the physical and occupational therapy needs must be both academically and medically necessary. So here, the medical therapy program is administered as a partnership between county health departments and the California Department of Healthcare Services in collaboration with local education partners. So examples of eligible conditions for this program would include cerebral palsy, neuromuscular diseases such as muscular dystrophy, musculoskeletal diseases. There's a bunch. It can also include, burns and traumatic brain injuries. And the full list is on the DHCS website. And these services must be things that CCS would otherwise cover, and it must be included in your child's individual education plan. Great. So now we're going to talk about medical tests. We just spoke about the age requirements. The child has to be less than 21. We spoke about the income requirements and the ways that can kind of be waived where income wouldn't be consideration. So now we're going to talk about the medical requirements. And the complexity of the California Children's Services is really due in large part to the huge number and wide range of eligible conditions. There is no typical CCS recipient. So children can get CCS if they have physical disabilities or illnesses which are serious and severe. And these illnesses include, but are not limited to, infectious diseases, diseases of the nervous, eye, and circulatory systems, nutritional or metabolic, immune diseases, diseases of the blood, respiratory systems, musculoskeletal systems. It even includes accidents, poisonings, if you ingested drugs to the point where it became life-threatening, burns, immunization reactions. That link there will provide you with the long list of conditions. It's quite comprehensive, but it's easy to navigate. However, and this is included in that link, mental health or intellectual disabilities alone will not meet the CCS medical eligibility test. So for example, if your child has schizophrenia, they would likely not meet the CCS medical eligibility test. However, if they have a disease of the eye and schizophrenia, then they would be eligible. And medical eligibility will be determined by the CCS program medical consultant or designee through the review of medical records that document the applicant's medical history, results of a physical examination by a physician, lab test results, radiology findings, or other tests or exams that support the diagnosis of the eligible condition. Next slide, please. Great, thank you. So now it's the residency test. So your child generally must be a resident of California in order to receive CCS services. And the residency of a child is typically determined by the residency of the parent or legal guardian, because typically the child lives where the parent or legal guardian lives. And the parent or legal guardian of the child must be a resident of the California county in which the application is made. So if you are applying in Orange County, you must be a resident of Orange County. And undocumented parents can be California residents. They just must show that they and the child live in California and intend to remain indefinitely. And you can show that by your physical presence. You rent a house, the child is enrolled in school. There is no plans to leave that county or at least the state. Great. So we spoke about age, we spoke about the medical tests that are administered, and we spoke about the income test. And with the income test, it is similar to fees, but fees are kind of more of a one-off thing. It's not really based on income or anything. So there are two types of fees. There is an annual enrollment fee and a sliding scale fee. And these fees are generally used to help cover the cost of treatment, processing applications, telephoning hospitals, physicians, caregivers, mailing authorizations, and coordinating care with the CCS agency. And all these services are provided by the CCS program to ensure that clients receive the best care possible from physicians and specialists who provide medical care to children. So we first have this annual fee, and most families must pay a flat fee of $20 each year. However, you do not have to pay the annual fee if your child has full scope Medi-Cal without a share of cost. Your child gets therapy at school, such as occupational therapy, through CCS as a related service in their IEP. Your family income is less than 100%, of the federal poverty level. So 100% of the federal poverty level for a family of 4 would be $27,750 in 2023. And we provided a link to that chart where you can see the annual poverty levels and based on the different number of family members. And you also would not have to pay the annual fee if your child is on the optional targeted low-income children's program. So on January 1st, 2013, the Department of Healthcare Services created this program, the Optional Targeted Low-Income Children's Program. And it proceeded to transfer children that were in the Healthy Families Program to this program. And so the Optional Targeted Low-Income Children's Program is a Medi-Cal premium payment program for children from the ages of 0 to 19. So if your child is in that program, they would not have to pay the $20 fee each year. Next slide. Great. So that was the one flat fee you would have to pay. There's also an enrollment fee. It's sliding scale, which means it really depends on the family size and income. So it really depends, the amount of the enrollment fee depends on how much money a family makes and how big the family is. So for example, a family of 3 earning $40,000 will pay an enrollment fee of $300 plus the $20 assessment fee each year. And family size includes everyone in the household who depends on the parent's income. And family income includes the gross income of the CCS eligible child and his or her birth or adoptive parents, which is something we discussed previously. However, CCS does not count any income from child support to brothers or sisters, the income of a step-parent who has not adopted the child, or other adults in the home, even if they help with family support. Great. So as with the other tests, there are some caveats where you may not have to pay, or you will not have to pay this fee if your child needs medical tests and diagnostic services to decide whether they meet the medical eligibility test to receive CCS. Your child receives full scope Medi-Cal with no share of cost. your child only needs therapy services, and therapy services here mean physical or occupational therapy. Your family income is less than 200% of the federal poverty level. So for example, 200% of the federal poverty level for a family of 4 would be $55,500. If you are making less than this, you would not have to pay for those fees. And again, we provided the link to the federal poverty levels for 2023 in the previous slide. So if you, that can help, that can be of guidance in determining whether you would have to pay this fee. Or your child is covered under the optional targeted low income children's program. And as discussed, that is a premium payment plan where for children between the ages of 0 and 19 years old. So as with a lot of families, this enrollment fee can be pretty burdensome to have to pay a couple $100, give or take, depending on the size of your family and income per year. So if you can't afford to pay the enrollment fee, there are options. First, you can ask CCS to reconsider the amount of your enrollment fee if paying the fee causes your family an undue hardship. And an undue hardship can mean a lot of different things. So for example, the family now has less income, either due to unemployment or a change in job or unavoidable expenses that reduces the ability to pay. When that happens, and if the county does determine there is in fact undue hardship, the county may then reduce or waive the fee. You would need to make the request in writing to the county CCS office and explain why paying the fee will cause you great hardship. After that, the county CCS director will decide whether you still have to pay the fee or if the fee should be reduced or eliminated. And also monthly payments are always available when it comes to the enrollment fee. So you can ask to make monthly payments if paying the entire fee at once will cause you hardship. All right, so we just went over a brief description of what CCS is. We spoke about the whole child model program, and we spoke about eligibility, which includes age, income, medical, and fees. So Daniel is now going to be speaking about services, how to apply, and the appeals process. But before we do so, if anyone has any questions from what was just discussed, we are more than happy.
The next. Okay, great. So now we're going to talk about the services that individuals can receive under CCS. Next slide, Raymond. Okay, so CCS will approve services that are medically necessary, like Nadia previously mentioned. So what does medically necessary mean? So these services are defined as those services, equipment, tests, and drugs or medications, which are required to meet the medical needs of the client's CCS eligible medical condition. So it has to be something connected to the CCS eligible medical condition. As prescribed, ordered, or requested by a CCS physician, and which is approved within the scope of the benefits provided by a CCS program, the CCS program. So that's the word verbatim, what they define as a medical necessity or a service that's medically necessary. Next slide, please. Okay, so what kind of services would this include, right? And Nadia did mention a lot of these already, right? It can include doctor and hospital services, services in a rehabilitation center, prescription medications, medical supplies, durable medical equipment, including braces, wheelchairs, electronic or manual communication devices, if there's communication disabilities or barriers, medical transportation, in-home nursing services. So these are just a few, not in the extensive exhausted list, but these are a few of the services that can be included in this. Next slide. So another service that's provided is case management. And in some cases, this is very helpful. So case management includes the following. Determining a medical eligibility for a child, deciding a child's medical needs, helping the child see special doctors or specialists, and helping the child receive services to meet the child's special healthcare needs. And this also includes help to coordinate the child's medical care and also includes referrals to other agencies if that's necessary. So every CCS client receives case management. If the child has Medi-Cal or, like Nadia mentioned earlier, right, and she spoke a little bit about it, the optional targeted low income children's program, and also has a CCS eligible condition, CCS can coordinate your child's medical care. Next slide. Okay. So another service under CCS is our special care centers. So these are our centers that provide comprehensive coordinated healthcare to CCS clients with very specific medical conditions. And special care center teams or providers evaluate the child's medical condition, and they help develop a family-centered healthcare plan that would be most effective for the individual, right, in addressing the needs, the medical needs. And examples of conditions that may require a referral to a special care center include the following: complex congenital heart disease, inherited metabolic disorders, chronic renal diseases, chronic gastrointestinal diseases, chronic lung diseases, malignant neoplasms or cancers, blood problems such as hemophilia or somebody that has sickle cell disease, severe immunologic disorders. Not listed here, right, can include communication disorders, epilepsy, someone that has spina bifida, or even genetic skin disorders. And here we have a link to where it provides information of where these special care centers can be located. And there's a list of them. So in other words, CCS has centers across the state that can provide special care for certain medical conditions. And these centers are usually designated hospitals or medical centers that are equipped to provide the specialized care that's needed to address a very specific medical condition. And of course, the goal being to create a family-centered care plan for the child that would be the most effective, right, in addressing and trying to ameliorate the effects of a CCS eligible condition. Next slide. Okay, so who provides CCS medical services? So each county has a panel of doctors, podiatrists, clinics, or special care centers, as we previously discussed, hospitals and therapists who meet CCS standards and are approved to provide CCS services. So not every doctor can be impaneled, right, or paneled with CCS. They have to meet very strict criteria. So if a child's own doctor or hospital is on the CCS panel, they can simply provide the treatment for the child and CCS will pay, as long as one receives CCS's approval first. And that's important because if a provider is not approved, right, or is not paneled with CCS, it indicates that they have not demonstrated the advanced education, training, or experience required to render services to a CCS client with very specific needs. In other words, a provider has to be approved or paneled by CCS in order for them to provide services to a CCS client. So if the child's medical provider is not approved by CCS, ask the CCS office to give you a list of other panel providers or approved physicians by CCS who are approved and can provide or render services that are needed. And at that point, one should think about switching to another provider, right, if the provider they are seeing is not CCS approved or not paneled by CCS. Yeah, so it's important that your child be seen by clinics and doctors that have experience with your child's special condition. And then here we have a list of CCS providers, and you can, and it's an extensive list, but it's broken down into locations and areas, but it's a list where you can find all of the CCS providers that have been approved. Next slide. So now the question is, does CCS have to approve services? Generally, yes. Of course, one contingency, right? One requirement is that you have to ask CCS to approve a service before your child begins receiving the service or treatment. Unless there is a prior authorization, CCS will not pay for the service. However, CCS in certain circumstances and in the context of emergency situations, when there's an emergency situation, CCS may approve a service retroactively. If the services were provided when the CCS office was closed, think weekends, right? And the CCS office is notified by the service provider during the first day that the CCS office is next open, the next business day, in other words. And you need to make certain that your doctor, clinic, or hospital contact CCS immediately after emergency services are provided. That way you don't get stuck with the bill at the end if there is one. If you have other insurance, ask the doctor, the clinic, or the hospital to get prior authorization from CCS, even if you think your insurance will cover the cost, because you want to ensure that there's prior approval. And if the proper procedures are not followed, unfortunately, by a doctor or hospital, CCS can refuse to pay, and you could ultimately be held responsible for the bill or any outstanding balance if there is any. So as a general rule, right, always get approval from CCS before pursuing any service or treatment under CCS. Next slide, great. So what is CCS's medical therapy program, otherwise known as MTP? So the CCS medical therapy program is located in public schools and provides medically necessary physical and occupational therapy, as well as physician consultations to children with CCS MTP eligible conditions, such as neurological or musculoskeletal disorders. And so think of any condition that would require physical or occupational therapy, right? And most most areas, right, have these MTPs in elementary schools, for example, but they're usually in a public school. And yeah, so CCS may require that you take your child to an MTU for treatment, right? And will not always let you go to your own therapist, unfortunately. However, sometimes CCS will approve vendor therapy, meaning you want a private therapist to see your child, right? At a hospital or private office instead of the MTU. However, it's important that that vendor therapist is paneled by CCS. And then, of course, you also have to demonstrate that there's a specific need that can't be obtained at the MTU. And then if your child has Medi-Cal and you don't want to go to the MTU, you can go directly to a doctor or therapist who accepts Medi-Cal. So you're not necessarily obliged or forced to go to the MTU if you are also under Medi-Cal, because in that case, you can go to any Medi-Cal eligible therapist, right? Any therapist who accepts Medi-Cal. And there's no financial eligibility requirement for MTP services. And this is because, let's say, for example, this can be used in the context of a special education, an individualized education program, right? Where we have a special education student who requires occupational or physical therapy to function in the classroom or to more effectively learn in their environment. And in this case, for that reason, right, there is no financial eligibility requirement because it would be needed under an IEP, for example. So that's something important to consider. And here we have a link to MTP. It provides more information. And then also within that, there's an MTU directory where it lists all the MTUs across the state. I think some of you are in Sacramento County. Some of you are not, but I believe in Sacramento County, there's 3 MTUs. Next slide, please. Okay, so now let's talk about services that CCS will not pay for. So the following are the services that CCS will not pay for. They won't pay for a service if it wasn't authorized or the authorization has expired. If you did not use a CCS approved provider, if it's not a CCS covered service, if the child is not or is no longer eligible for CCS, if the child's parent did not follow the treatment plans that were suggested or proposed by a physician, or they fail to keep their scheduled appointments, if the service is not for an approved CCS eligible condition, if the parent or guardian hasn't paid the required CCS fees, if the medical treatment has been completed, or if the service your child needs is fully covered by another health insurance plan, which doesn't include Medi-Cal or the optional targeted low-income children's program. And next slide. Okay, so now how to apply, right? What is the appeals process for a CCS determination? Next slide. Okay. Oh, sorry, how to apply. I apologize. So how to apply. So to apply for CCS, you can do this online, right? Here you'll find a link to an application and the list of county CCS offices where you can send the application. The application is in English and Spanish, the one provided online. But even if you don't speak or write in English nor Spanish, right, you can reach out to the county CCS office if you need assistance in a different language, because CCS must accommodate a person's language access needs. So if you speak another language, you can call the CCS office, interpreter can help you and they can help you fill out the application. Also keep in mind that if a person is applying for CCS but doesn't have Medi-Cal, they may be asked to apply for Medi-Cal as part of the CCS application process. Because of course, if one is eligible for Medi-Cal, right, which may cover a lot of these services, then they're going to be required to apply for Medi-Cal first. Great. So now the appeals process. So next slide. So let's say we're in a situation now where there's a decision, right? And you agree with the decision by CCS, and the decision being that they are denying your child a service. What happens? What can you do? Well, you can appeal. In other words, right, you can go through the process of challenging a decision that has been made by CCS. I mean, there's important information you have to consider, though, right? Who you appeal to, the process to follow, and the timeline for appealing. And it all depends on whether you're in a whole child model program or not, and whether it involves CCS initial eligibility or not, right? So if your child participates in the whole child model program, and Nadia stated, right, it's akin to all the rules from CCS apply, but in some instances, the rules are a little different, right? If your child participates in the whole child model program, if one wants to appeal, they'll need to follow the Medi-Cal Managed Care Plan's appeal process. So Medi-Cal has its own process to appeal a decision, and CCS has its own. So during the course of this presentation, the Medi-Cal Managed Care Plan's appeal process is not within the scope of the information we're provided, but we will talk about the CCS appeals process. But we do want to note that the whole child model program follows the Medi-Cal appeals process. Next slide. So now let's first talk about things that can't be appealed. Is there anything that I can appeal? That's the question, right? And the answer in short is yes. If your child's CCS primary care physician orders, reduces, or terminates a service and you disagree, there's not a traditional appeals process, right? You'll then, if you disagree, you'll be given the information of 3 expert doctors, and you're going to be asked to choose one. And these doctors are not directly employed by CCS, right? They're doctors that are paneled by CCS, meaning they meet the rigorous, stringent requirements under CCS, but they're not directly employed by them. So in turn, they're supposed to be neutral and objective. So this expert doctor, you can choose one, and they'll evaluate your child, and his or her decision will be final, right? In terms of the services that are, or the denial of services, termination of services that are being appealed. And also it's important to note that this expert doctor doesn't have to be one on the list. You're also entitled to ask for any other expert doctor that is also a panel doctor with CCS, right? You're not limited to those three, because it may be a situation where you research those doctors and then find that they're not satisfactory, or you find something and you find that these probably are not the best doctors for your child. You can go out and look for one that is paneled, and you can make the request saying, I found this doctor. I believe this doctor will evaluate my child thoroughly and their needs. So that's a possibility as well. Now, if that's denied, there's room there, right, to appeal further and to challenge. But as a general rule, you're entitled to do that. So another instance, right, where something necessarily can't be appealed. So you don't have a right to a hearing if the only issue is a federal or state law requiring an automatic change adversely affecting some or all recipients. And Nadia stated earlier in the disclaimer slide that, right, that laws are constantly developing and changing. So there are situations when laws change, and as a result, it may affect the policies and procedures of certain programs. So let's say that there's a change to a law in California that affects California Children's Services. And it's a change that would also affect some or all CCS clients. Then that cannot be challenged at the level of first appeal, right? There can be systematic litigation, right? Like organizations like Disability Rights California, who will try to challenge the rule or the law, right? But on a first level appeal, that's not possible. You wouldn't have that remedy or recourse, unfortunately. So that's another situation where one cannot appeal. Next slide. Okay. So under CCS, right, if there's a decision made, if there's a change, if there's a termination, if there's a reduction in a service, one should receive a notice of action. And a notice of action is simply a written notice by a program or entity that presents information about how a program, service, or benefit will change. And it provides reasons as to that change, and it will also provide information as how you can challenge the decision or appeal. So generally, well, no, this is a law, right? One generally must get a notice of action within 7 calendar days of a decision by a CCS agency. And in the following circumstances, right? If the applicant is denied eligibility for CCS, if a request for a new medical service or program benefits not currently being provided to a client are denied, if a continuation of CCS medical service or program benefit that is currently being authorized is terminated or denied, or if the client's eligibility for the CCS program is discontinued, or if the amount that the family must repay let me read that again. Or the amount the family must repay the program for treatment services is increased. So if there's an increase in the amount that is normally paid, right, you have to get a notice of action, right? That's an adverse effect. And in most cases, when one has limited means and income, that can be significant to a household. So, but even then, however, if a family agrees with the new amount, they can sign a statement agreeing to the new amount. And that statement has to be prepared by either the family or the agency. If that's done, then the signed statement constitutes a written notice of action. In that case, no form is required. In other words, if there's an increase in a fee that must be paid, you have to get a written notice of action, right? And particularly in a case where you want to appeal it. But sometimes, a CCS worker will tell you, we plan to increase this fee by this amount. Are you in agreement? Do you agree with this? And sometimes the amount is not steep, right? It's not significant enough where one would want to appeal. In that case, you can simply say, yes, I agree. And then if a statement is signed stating that you agree with that increase, then that signed statement becomes a notice of action. And another situation, oh, sorry. Thank you, Raymond. So let's say there's a situation where a service is approved, right? But is then modified by the CCS program to reduce the frequency or duration of the service, to change the place or the provider of the service, to alter the nature of the medical services or the benefit requested, then that would also warrant a notice of action. So these are the situations in which a notice of action or an NOA should be provided within 7 calendar days. Next slide now, Raymond, thank you. So when wouldn't you receive a notice of action? There are situations where you wouldn't receive a notice of action. One of them, right, being if you sign a statement stating that you agree to a fee increase. Another one would be the reduction, termination, or modification of current services or benefits does not require a notice of action in the following situations. If you agree with the CCS action, for example, a fee increase, if your child's CCS treating physician who oversees your child's care ordered the reduction, increase, termination, or modification of services or benefits, in that case, right, you'd get the 3 lists of expert doctors and then you would choose one. And so it's not the regular appeals process. The next situation would be if your child was authorized services for a limited duration, you were told this and the service or benefit ended on the date it was set to end. For this particular situation, I want to expound a little bit on it. So although you don't get a written notice of action, you can still appeal this determination. You can still appeal this decision. So, but it's important, right, to communicate with the CCS agency before the cutoff date. So if there's a service that has been approved for a limited amount of time, but you believe that the timeline should be extended, right, that your child should continue to receive benefits, you want to extend the time frame, you can, right? You can ask the CCS agency to consider increasing or extending the timeline because your child needs it. Yeah, so you're entitled to do that. And also, though, again, we're not going to cover Medi-Cal appeals processes here. We're not going to cover the Medi-Cal appeals process, but that's also something that you can pursue as a remedy if you receive Medi-Cal. And then another situation, right, is if your child is in an acute care or subacute medical care facility. Next slide. Thank you, Raymond. Okay, so now what is a first level appeal to CCS? So there's different steps to an appeal. The first level, we call the first level appeal. So when you're dissatisfied with the CCS decision, you can appeal. Your written request for an appeal must be postmarked within 30 calendar days of the date of the NOA, not the date you actually receive the notice. For some programs, that's different. The clock starts counting when you receive the notice, generally, right? But for a CCS notice of action, it's 30 calendar days from the date of the NOA. And then your appeal has to describe the issue, provide information to support your position, indicate what it is that you want changed or restored, and has to include a request to continue services during the appeal, if that's something you're pursuing. So as previously stated, if you don't get an NOA, you could still file an appeal. You should file your appeal within 30 days of the action that you are appealing. So say there's a reduction or there's a termination of a service, and you were told verbally, but you didn't get a notice of action. As soon as that service is terminated, appeal. Just send a letter to CCS saying, I am appealing this decision. It was verbally confirmed that it would be terminated, the service would be terminated, and I disagree with this. And there's no specific language that you have to use for the appeal, but CCS offices, the agencies and regional offices do have a form. Unfortunately, it's not made publicly available on the website, but they do have those forms and you can request one. Next slide. Okay. So after you appeal, CCS will review your written request without holding a hearing. Not yet. And so CCS has 21 calendar days after getting your appeal to review it and mail a written response. And this response is called the appeal response letter, or an ARL. And CCS's response must explain the reason for the CCS decision. It must include the facts and the laws that support that decision, allegedly. CCS may decide that it needs additional information to review your appeal. So instead of giving you a written response, CCA may ask you to give them more information or more documentation. And CCS has 14 calendar days to make this request. So if this happens, then CCS has 21 days after it gets your additional information to make a decision, to provide a written response. In any case, right, we're working with 21 days. That's generally how long, calendar days, how long CCS has to issue a written response. So if CCS decides against you in the first level appeal, this is the point where you can ask for a fair hearing. Next slide. So you have 14 days from the date of CCS's written decision to file a request for a fair hearing. And the fair hearing is administered through the DHCS, the Department of Healthcare Services Office of Administrative Hearings and Appeals, or OAHA. And in that written decision, there needs to be information about the specific procedure for the fair hearing and exactly what you need to do to request one. So when you do decide to, if it's what you decide to do, to appeal further and pursue a fair hearing, you would fill in all the information, right? And you would also include the written decision from CCS if it's an unfavorable decision. So yeah, so you generally have the 14 calendar days from the written decision, but if there's good cause as to why you decided to file for a hearing later, you have to provide that. That could be, example, let's say you were in the hospital for 2 weeks, right? And you couldn't possibly have submitted an appeal on time because you were in the hospital. That's good cause. That's the type of good cause where you would still be able to file for a fair hearing. Next slide. Okay. So will services be continued during the appeals process? So let's say they're planning to terminate a service and you appeal. In that appeal, you can request that the benefits continue until your entire appeal is complete. This includes the 21 days, right, that CCS has to make a decision into the fair hearing process, right, until they make a final decision, an administrative law judge at a fair hearing. So services may continue during the appeals process if all of the following applies. CCS already authorized a service, right? You're already receiving a service. You requested in your written appeal that the service continue. So for this, you have to use specific language, right? So good language would be, I request that these services continue until my appeal is decided or complete. So if you have that language, then that should immediately trigger the aid paid pending, meaning you'll continue to receive benefits or services while your appeal is ongoing. And generally, the CCS rules say that CCS has to continue services if stopping or changing those services could cause injury or death to a child, or if your child will lose physical function or get worse without that service or treatment. Also, your request, the other has to apply, right? Your request was determined to be medically necessary by a CCS authorized physician, meaning that you're requesting for a service to continue, right? And then a CCS authorized physician has to vouch for that. They have to confirm that that is the case. So if services are terminated because CCS has found that the child is ineligible due to a non-medical reason, for example, that parents' income is too high or they're not California residents, then a CCS doctor will determine whether you can continue services during the appeal, a CCS doctor, so a CCS employed doctor. But if services are terminated because CCS has found that the child is no longer medically eligible, meaning that they no longer fall under that list of CCS eligible conditions, then another doctor who is not directly employed by CCS, but is a doctor that's paneled by CCS, that doctor will determine whether the child can continue receiving services during the appeal. And then the last thing, right, the length of time that services can be continued will vary depending on the length of the appeals process. And then the next slide. And here we have a few resources that you can refer to that are very helpful. We have the program overview of CCS by the DHCS, the Department of Healthcare Services. We have a link to the California Code of Regulations, where all the laws regarding CCS can be found. We have a handbook from DHCS regarding CCS. It's a good publication. And then we also have a link to CCS numbered letters and notices. This link actually leads you to more CCS resources, including manual procedures, CCS medical eligibility guide, which tells you, right, where medical eligibility can be found. Like Nadia stated, right, there's very specific ones, but they're broad enough where you can possibly argue that a condition will fall under one of those requirements, or those CCS eligible requirements. And then numbered letters, which are letters from DHCS that are addressed to CCS administrators. So these letters act like a guide as to how the CCS program should be administered, right? There's the laws, and then there's these letters that are guides to CCS workers, representatives, agencies. And then lastly, we have the CCS Case Management Manual, which is a manual of administrative procedures that's used by CCS workers, representatives, agencies, offices. And towards the end of this particular manual, there are flowcharts that help illustrate the timeline of a CCS matter from the very beginning, right, when they're determining eligibility, all the way to the appeals process. I think that information is helpful. But yeah, these are good resources to refer to. And then I think we can go to the next slide and stop the recording so we can take